Okay, good morning, everybody. This is the Committee on Corrections, Military, and Veterans, formerly known as Public Safety. My name is Mark Hashem. I'm the chair of the committee. To my left is the vice chair, Corey Chun. Today is Friday, February 3rd, 2023. It's 9 a.m. We're in conference room 430 at the State Capitol on 415 Beretania Street. We're going to jump right in. And first up, we have HB 824 relating to medical release. First, to testify, we have Tommy Johnson, Department of Public Safety, with comments.
Thank you. Good morning, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Director of the Department of Public Safety. I won't go into detail, but we did provide 8 pages of testimony that provided statistics, the number of cases, the cost for this measure, if this measure were to pass. In short, the system currently in place works. So I would caution the legislature about trying to fix a system that's not broken. And to me, this appears to be a bill that's looking for a problem that does not exist. I'd appreciate if you read our detailed testimony. It provides information regarding the entire process. I'll be here to answer any questions.
Okay.
Thank you.
Thank you very much. Next, we have Hawaii Correctional Oversight, or Hawaii Correctional System Oversight Commission. In support. Can you get a shorter name?
The commission.
Yeah, the commission, Correctional Commission.
Okay. My name is Martha Torney, and I'm one of the commissioners on the commission. And we support this measure as we believe that inmates who pose low risk to society due to illnesses, disabilities, and others should be released into the community. We believe this bill reduces the population, reduces the cost to the department, and elevates the level of humanity in corrections, which will align with our rehabilitative and therapeutic process. We do want to bring to your attention, it's also important to note that within the last 2 months, 2 inmates died in custody. One individual was 73 years old, the second was 87 years old. Both were in the infirmary when they died, and we prefer that they should have been released in that. As of this date, there are 17 individuals housed within the jail or prison infirmary, and 6 individuals housed due to complex medical issues. So we support this measure. Thank you.
Okay, thank you very much. Next up, we have Hawaii Paroling Authority with comments.
Good morning, Administrator Corey Ranky, sitting in for Chairman Freddy Witness in hearings today. We stand by written testimony.
Okay, thank you very much. Next up, we have Hawaii Disability Rights Center in support. Not here. Next, we have Hawaii Health Harm Reduction Center in support. Next, we have Community Alliance on Prisons in support. Cap Brady.
Good morning. Good morning, Chair Hashem, Vice Chair Chun, and members of the committee. Kat Brady testifying on behalf of Community Alliance on Prisons. We strongly support this bill, and we think it should be in statute. Thank you.
Okay, thank you very much. Next, we have Robert Merce in support.
Chair Hashem, Vice Chair Chun, my name is Bob Merce. I've been working with public safety and sometimes against public safety on compassionate release for the past 10 years. And I'm a strong supporter of this bill. Let me address, instead of talking about the substance of it, is to talk about the resistance that has arisen from the department and sometimes from the parole board. Number one, if someone, there's no law that prescribes a process of compassionate release. So if somebody wants to help a relative or a friend or their son or daughter, if you look in the statute book, there's no statute on it, because my first case, that's where I looked for compassionate release. There's nothing on it. You look at the department, I've worked with the department. They have a good policy. The policy describes the process on their side, but not on the side of the parole board. And the two have to work together, and they have very different criteria for granting compassionate release. That needs to be fixed. This bill would fix it. Further, the important thing is that the whole release process hinges on one sentence in an administrative rule that was adopted by the department, by the Hawaii Paroling Authority. It doesn't even mention releasing prisoners in 1992. It simply says we have the authority to reduce the minimum term of imprisonment if a person can't be cared for by the department or death is imminent. So you will not find the words compassionate release, medical release, or anything in any of the of the rules and regulations of the parole board. So it's basically an invisible process. I know it pretty well because I've been doing it for 10 years, but other people don't. And it needs to be codified so that everybody is on the same page. We know what the rules are. We know what the duties and responsibilities are. We know what the process is. We have some time limits on the process because these are often time sensitive. The people are dying. And so this bill is really essential. So the governor vetoed it last time saying we don't need it. We do need it. Secondly, the department has, I know, always taken the position that the bill does have a lot of reporting requirements in it as it's presently drafted. I've taken those to heart. They were part of the reason that bill was vetoed before. I put in my written testimony how we can really shorten that up, because really all the information that people need is the director, before he sends something over to the parole board saying release this person, he needs to know the diagnosis, the prognosis, and whether he's going to recommend release because the person is a good candidate for release because they're not dangerous. Those are the only things that really matter. So the director needs to get a report from his or her medical staff saying, you know, what is the diagnosis? What is the prognosis? Do they meet the criteria? And are they a safety risk or not? Very simple. That is the information that the parole board needs to make a sound decision. So we can shorten that up. My recommended amendments will shorten the bill by about 2 or 3 pages. And it won't cost any money because the people who are caring for them will have that information at their fingertips at all times, because you have to know those things if you're caring for the patient. Thank you very much.
Okay. Thank you very much. Next up, we have on Zoom, Hawaii Health Harm Reduction Center in support.
Aloha, Chair, Vice Chair, and members. Nikos Leverins on behalf of Hawaii Health and Harm Reduction Center. We strongly support this bill. We've supported prior incarnations of it when the current Lieutenant Governor introduced it, and we hope that due consideration will be given to potential expansion of this bill along the lines of the Federal First Step Act. Mahalo.
Okay. Do we have anybody else on Zoom? Seeing none. Is there anybody else wishing to testify? Oh, please stand up. State your name and go ahead.
Aloha Kayaka, Chair, Vice Chair, and the committee. My name is Angela Melody Young, testifying on behalf of CARES, and we are in strong support for the safety of the ill and the disabled. So researchers have found that the vast majority of individuals who are placed in solitary confinement have experienced behavior issues, and that's why they are there in the first place. So solitary confinement can exacerbate symptoms. So now with all the
you're on the wrong bill. It's about compassionate medical release.
Oh, I'm on the wrong bill. HB 284. So release program for the disabled.
Yeah. That's solitary confinement.
Oh, but then if they're in jail, they get released, right?
Okay, no, go on.
Oh,
okay,
okay.
Continue. Sorry.
So I think my point is just that it is good that they get released so that it doesn't keep exacerbating the mental conditions that they suffer from, because jail exacerbates it.
Okay.
Thank you for the opportunity to testify.
All right. Thank you very much. Sorry for interrupting you. Okay. Anybody else wishing to testify? Seeing none. Members, are there any questions? Seeing none, we are moving on. Next up, we have HB 1235 relating to corrections. First up, we have the Hawaii Correctional System Oversight Commission with comments.
Okay. We support the intent of this message, but we do ask you consider extending to all facilities that include women, which are all the CCCs in the state. And we do want to bring to your attention at this time, only 30% of the Women's Community Correctional Center has cameras that, or monitor areas of the facility. That means 70% of them are, of the rest of the facility, are blind spots for this purpose. So we do encourage you to pass
Okay.
this.
Thank you very much. Next, we have Tommy Johnson, Department of Public Safety, in support.
Thank you. Good morning, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Director of Public Safety. I'll just summarize my testimony. We already put aside $1.2 million in federal ARPA funds. We hired a consultant who's already completed the work at WCCC in reviewing the security camera situation. The company is Bowers and Kubota. They will be providing us with a final report on their assessment during end of February of this year. Based on that, we will proceed with the RFP process. That $1.2 million covers a consultant to review the security cameras at each facility to see which ones are working, which ones are not, if the system's able to talk, do we need to replace security cameras, and also do we need to install additional security cameras in the facilities. And so I have committed to placing additional federal money that we have on the side to this project if it's more than $1.2 million. So we've already started that process. The second thing is, with respect to the functioning body cameras, we respectfully request that this measure be amended to request the department complete a feasibility study regarding this issue, and that it includes all facilities statewide, not just the Women's Community Correctional Center. The study would determine the applicability and the need for body cameras throughout the correctional facilities, the cost to procure them, the cost to maintain them. Storing the data will be expensive. But again, we don't oppose the measure. We just would prefer to do it across the board in all the correctional facilities and get a feasibility study to find out what the cost will be so we can present that to the legislature. Thank you. I'll be available for any questions you have.
Okay, thank you very much. Next up, we have Kailua Neighborhood Board in support. Next, we have UPW in support, or with comments. Sorry.
Chair Hashem, Vice Chair Chun, Kamakana Kaimaloa, Government Affairs Manager for UPW. UPW stands on its written comments and be happy to answer any questions you may have. Thank you.
Thank you. Next up, we have Community Alliance on Prisons in support.
Aloha, Kat Brady testifying for CAP. We are in strong support of this, and the genesis of this bill was the lawsuit that happened in November, where they found that 53 women had been sexually assaulted over 3 years. This is ridiculous. So I definitely believe body cams are important, and I agree with the amendment that, we should be, all facilities that house women
Okay.
should have these cameras and body cams.
Okay, thank you. Next up, we have Anuhea St. Lawrence Marriage and Family Therapy in support. Next, we have an individual. I can't read the name. Ms. Reed in support on Zoom.
Hi, can you hear me?
Yes, go ahead.
Okay. Good morning, Chair, Vice Chair, members of the committee. My name is Tishalyn Reed, and I'm strongly in support of House Bill 1235. I just want to say I am a founding member of a corrections officer and a female incarcerated. And I believe this bill will not only help the incarcerated females, it'll help the correction officers as well for their safety and the safety of the inmates. I also want to say that, yes, in November, the lawsuit that the federal government alleged 53 sexual assaults. I mean, that's a lot in 3-year span. So I just want to say again that I am in strong support of House Bill 1235, and I also believe that it should be in all prisons. Again, thank you for letting me testify.
Okay, that is all that we have registered to testify. There we have probably 10 more individuals in support. Is there anybody wishing to testify? Go ahead.
Aloha, Kayaka Chair, Vice Chair, and the committee. So I'm Angela. I'm testifying on behalf of CARES. So we specialize in advocacy and research. So usually I'll present credible research from a credible source that I then cite in the testimony, the written testimony, and to set up the premise to either support, oppose, or to provide comments. So,
Okay.
Yeah. Okay. So I'm testifying in strong support of HB 235. The purpose of this act is to require the Department of Public Safety to install cameras at the Women's Correctional Center, and requires guards to wear body cams and then appropriates funds. So I'm in strong support because of the insidious nature of the things that have happened to the women there. And so cameras can catch crime, and also in court, it will be less of a chance to contest camera evidence. So it's like 100%, for sure caught on camera. And at the city, they introduced overt video monitoring in Campo Industrial Park to prevent and to deter criminal activity. So you can see that there is support for these sorts of measures. Thank you for the opportunity to testify.
Okay, thank you. Thank you very much. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Oh, Representative Ganadin, go ahead.
To the commissioner, Ms. Harney? Yes. The commish. Under the statute that authorizes the commission, do you believe that you have direct access to the footage that's going to result from these cameras, or are you going to have to go through some sort of form or process with the department to get access to them?
It allows us to have access to all types of material, and we would work with Director Tommy Johnson to get that information. I do want to let you know that Tommy Johnson has been very cooperative with us.
That's great to hear. Thank you.
Thank you. Anybody else wishing?
Yeah.
Anybody else with questions? Representative Morikawa, go ahead.
Thank you, Chair. My question is probably going to be for Tommy Johnson. I'm trying to remember, you have a whole bunch of safety officers that got merged together, right, in a separate section. Is that under you guys?
Well, no, it's the Department of Law Enforcement that was just recently created.
So it doesn't include the sheriffs and
No, it does.
their guards?
But with the sheriffs, narcotics enforcement, executive protection for the governor, lieutenant governor, harbors, AG investigators, and other entities will spin off and become the Department of Law Enforcement.
Okay. My question would be about the body cameras. Do you know of any officers currently that have body cameras?
I believe some of the sheriffs may, I'm not sure, but the corrections officers do not.
Okay, so I'm just concerned about UPW's testimony about having to negotiate that. So you're aware of that?
That is a negotiable item, that is correct. So part of the feasibility study would be, once we got the report back from the consultant, would be then to work with DHERD and the appropriate unions to discuss implementation, what would it cost, what do they ask from UPW, and then what the employer can provide.
Okay, because I think you might need more time, right, to do something like that.
Yes, that's correct.
Okay, thank you. Thank you, Chair.
Okay, all right.
Oh, I have a question actually for the commission. Thank you. Also, just a disclosure that my cousin is Mark Batterson, chair of the Oversight Commission. It's related to everybody. So I just have a question about, fully supportive of the intent of the bill. However, I just kind of wanted to know that, cameras are one component. Have you guys looked into other remedies as far as alleviating the fact that these correctional officers are engaging in sex assault, as we have seen in the past, whether it's hiring practices, or is there something in conjunction to the cameras that will be installed through this bill?
It won't happen through this measure, but the commission is very concerned about training of officers and supervision of officers.
Okay.
And those will help resolve some of this.
Okay, thanks. I just wanted to know generally. Mahalo, Chair. Thank you.
Okay, thank you very much. Anybody else wishing to ask questions? Seeing none, we are moving on. Let me get my place here. Next up, we have HB 861 relating to corrections. First up, we have Attorney General with comments.
Good morning, Chair Hashem and members of the committee. My name is Lisa Itamura. I'm the Deputy Attorney General assigned to this bill. As pointed out in the testimony, we do have comments. This bill does appear to violate separation of powers by giving the commission authority over an executive department. and also preventing or restricting the governor's ability to even ask for funds in the executive budget process for a project unless it's been approved by the commission. We do think that if you make the commission's advice only, not controlling over the department, that'll fix the separation of powers problem. And I'll be available for questions later on.
Okay, thank you very much. Next up, we have Hawaii Paroling Authority in support.
Good morning. Acting Administrator Corey Ranky on behalf of Chairman Fred HP stands by his written testimony. Thank you.
Okay, next up, we have Department of Public Safety in opposition.
Good morning, Chair, Vice Chair. I'm Tommy Johnson, Director of Public Safety. I'll just summarize our testimony real quick. But could we go back? You indicated that the Hawaii Paroling Authority was in support of this measure?
That's what I have on my... Okay, go on. Go on with your testimony and I'll go.
Okay, thank you.
review.
Okay, so in short, we oppose this measure for the reasons listed in our testimony and from what the AG said. There's some misinformation in the bill itself, which says that the public safety has not done considerable reach out to the community. Just real quick, we've attended 55 neighborhood board meetings, 25 community association meetings. We've put out 45 monthly newsletters. We've answered every inquiry that's come our way. We have just recently contracted with UH, and I signed the letters to send out to stakeholders to have talk story sessions about the vision for OCCC with the community, and the commission is part of that list of folks that will receive the letters. In addition, when you look at our testimony on this measure, we provide detailed information regarding the process that we've gone through, the issues we have with the bill, which are similar to the Attorney General's testimony, in that there is a separation of powers issue. If passed as is, this bill would take the commission from one of oversight to one of authority over the Department of Public Safety, and that wasn't the intent of the legislature when they created the commission. The commission and public safety were supposed to work together to better the correctional system for all, including the staff. This measure upsets that balance considerably by placing the commission in approval authority over a budget that really the commission doesn't know the priorities of the department and what our CIP budget looks like, what our maintenance issues are. So we would kindly recommend, respectfully request that the legislature look at our testimony in detail before you render a decision, and I'll be here to answer any questions you may have.
Okay, thank you very much. Next up, we have the commission with comments or support the intent.
Please excuse me, I'm going to be reading pieces of this and not just summarizing because it's very important. We do support the intent of this measure, which would require the commission to oversee the development of new and existing facilities, in effect giving us veto power over capital improvement projects involving correctional facilities. We appreciate the confidence that you place in our work. However, we believe that planning and construction or development of correctional facilities must clearly be operational responsibility of the Department of Public Safety and its successor agencies. While we do not believe veto power is appropriate for all, we can strengthen if we clarify the responsibilities regarding the department's capital improvement and operating budgets. So to accomplish this, we ask that first you delete Section 2, which would give us this power over the department when it comes to development. Also, I don't have this in the testimony, but also delete Section 4, which is the funding to support that. And we ask that you amend Section 3 by deleting the proposed amendment in there and replacing it with, and we have the language here, review and recommend amendments to the Department of Public Safety operational budget request and any capital improvement project appropriation requests prior to each legislative session to ensure that the funding and budget allocations align with the state's firm commitment to the correctional system's transition to a rehabilitative and therapeutic model. The commission shall inform the legislature if its recommendations are not accepted. We do strongly support Section 5, which provides public safety with the money for planning, and we ask that you also, the planning or replacement of or redevelopment of our facilities needs to really get on a fast track right away. So I just want to respond to one comment by the director implying that the commission does not understand the priorities and stuff in the commission. I want to remind you that Ted Sakai was director. I was deputy director. Mark Patterson is the head of the youth facility. We are all very, very familiar with state budgets and know how to evaluate them. So thank you.
Okay, thank you very much. Next up, we have Hawaii Health Harm Reduction Center in opposition.
Aloha, Chair, Hashem, Vice Chair, and members. With understanding that the Commission just weighed in support of various components of this bill, we believe that these powers fall outside of its current scope and mission. The Commission just hired a wonderful oversight coordinator, Kirsten Johnson, and its work. She's doing fantastic work, and we support further efforts along those lines to, sort of get, a real account of what's going on in our very problematic jail and prison facilities. And we also note that before we construct new jails or new prisons, this legislature must look at a whole host of reforms to reduce the number of people in our jails at any given point in time, and the list is quite long. So mahalo for the opportunity to provide testimony.
Okay, thank you very much. Next, we have two individuals in support. Are they here? Are they on Zoom? No? Is there anybody else wishing to testify? Seeing none, members, are there any questions? Seeing none, we're moving on. Oh, question?
I'll go fast.
Okay, go ahead.
So, Mr. Johnson, well, congratulations on your new position.
Thank you.
In our first hearing of the CMV committee. We all heard the State of the State address by the governor, discussing how he is interested in the development of a new facility. Do you think that you can move forward with the development of this new facility without the commission?
We can move forward without the commission, but if the commission's purpose is to help us take a look at ourselves and the system as a whole, it's better if we walk that path together, to be perfectly honest with you, because they'll come from a different perspective, and so they might see something that we don't. So I work closely with Christian Johnson. I know the members of the commission. I don't have a problem working with the commission. I think it's a good idea that if we do have the commission, that they work with the Department of Public Safety and not necessarily against it, not that that's what they're doing. But I think we all have to come to some agreement on some key issues, and we're not going to agree on everything, because I think we agree on there's issues, problems. I think we don't agree on how to fix them. And so that's up for us to work with the commission on, and that's what we intend to do, and that's what we've been doing. Max Otani and I, when we came on board in November 2020, unlike the previous administration, who didn't attend any of the hearings, we've attended every hearing. I missed one because I had a meeting to go to at the legislature. Otherwise, we've attended every hearing. We've included the commission in a number of issues dealing with OCCC and the department. Every request for information or data has been fulfilled, and we intend to continue that.
How do you follow?
Go ahead.
Thank you. How do you feel about the prospective amendments being offered by the Office of the Attorney General as well as the Commission to align this with the Constitution so that you folks can work together and come to the legislature, hopefully jointly, with a joint plan for a new facility?
Well, we can work with the commission, but in the end, public safety needs to be able to have the freedom to make the call with the executive branch on how we're going to proceed. But I want to make it clear, we are so far from that at this point. We're just asking for money for planning and design, $15 million next year, $10 million the following year. And we just provided a presentation to Senator Wakai, and we can provide the same presentation as commission. We can bring in the members of the commission were there, a couple of members of the commission were at that presentation. I think that might give this entity a better understanding of the infancy of the process we're in now.
Thank you.
Okay.
Thank you. Representative Takayama.
Thank you. If I may follow up with Mr. Johnson. Thank you, Director, for your comments about the commission. You know, as someone who is involved in the development of the legislation that created the Oversight Commission. The title oversight was meant to mean what it says. They should be regarded, in my view, and in the legislation that we enacted, to be a part of the Department of Public Safety, not adversaries necessarily, but to work cooperatively with you.
I agree.
Right? So given that, I take it you don't have any objections to having the Oversight Commission and the coordinator be a part of the planning process for the new OCCC or any other correctional facility?
No, I don't. In fact, we just had a meeting with the coordinator, and I indicated with Senator Wakai, and at that meeting we decided to have quarterly meetings moving forward to bring the commission in to see where we are and to get their input.
Okay, I'm glad that's occurred, because to me that's long overdue.
It is.
And you
I
know, the
agree.
process for OCCC has been ongoing for quite a while now.
Yes.
So thank you.
Thank you.
Chair.
Thank you. Any other questions? Seeing none, we are moving on. Next up, we have HB 1133 relating to public safety. First up, we have Department of Public Safety in opposition.
Good morning, Chair, Vice Chair, members of the committee. I'm Tommy Johnson, the Director of Public Safety. We provided some lengthy testimony, but I'll summarize that lengthy testimony real quick. In short, if this measure were enacted, we would not have an inmate telephone system. At present, Hawaiian Tel does not do facility inmate telephone system, so we have a private vendor. That private vendor charges 7 cents per minute per call. 15-minute call is about $1.05. I believe in the measure itself, it lists $13 and something for a call. The money from the system and 4% of the commissary profits go toward funding the SAVIN project, and that is the statewide automated victim information and notification system that when I was the deputy director in 2007, we were able to implement using federal grants. So the money doesn't come to the department per se for operating, it operates the SAVIN program. And so the inmates who committed the crimes are paying for the victims to be able to track their whereabouts, for lack of a better term, when they, after they move, if they're coming up for parole, so they can provide input to the appropriate agency. If this measure were to pass as is, we wouldn't be able to have a contract. We wouldn't have an inmate telephone system. We would have to come to the legislature to request millions of dollars for the system, because the inmates still need meaningful access to the courts and to their families. We don't have that infrastructure. This contract allows for that, and at the same time, it provides for a valuable public safety program, the SAVIN program. That's all I have, subject to your questions.
Thank you. Next up, we have PUC, Leo Sanchin with comments.
Chair, Vice Chair, members of the committee, Leo Asuncion, Chairperson of the Public Utilities Commission. Will stand on a written testimony with comments on Section 4, the section that pertains to the PUC. Basically, that we do have the rules already in there, and we do give the citation on where it is. If anything, probably clarification on what kind of rules that you folks, after looking at that particular rule, if there's any further amendments that need to be made. Thanks.
Okay, thank you very much. Next up, we have SAVIN Governance Committee in opposition. Next, we have Hawaii Paroling Authority in opposition.
Good morning, Acting Administrator Corey Ranky. Excuse me, standing in behalf of Chairman Fri Feb. Stand by written testimony for available.
Okay, thank you very much. Next, we have Hawaii Youth Services in opposition. Next, we have Crime Victim Compensation Commission in opposition.
Good morning.
Morning.
Good morning, Chair, Vice Chair, members. My name is Pam Ferguson-Brain. I'm the Executive Director of the State Crime Victim Compensation Commission. Thank you for the opportunity today to speak in strong opposition to this bill. What this bill does is it undermines the main funding source for Hawaii's crime victim notification system. By doing that, it jeopardizes the safety of crime victims in the community and effectively deprives crime victims of the ability to exercise their right to be informed about the movement of offenders and to be notified and heard during the parole process. These are all rights under 801D that we have for crime victims. And so that provides a significant problem and issue. We run the Crime Victim Compensation Commission, and we also, a member of our staff chairs the Savin Governance Committee. The Savin Governance Committee is comprised of victim service providers, victim advocates, technology experts, members of the criminal justice community. And when the Savin legislation was enacted as part of the Bureau of Justice Administration's recommendations about how to create a victim-centered crime victim Savin program, in order to create a balance between the Department of Public Safety and the needs of crime victims, they created the Savin Governance Committee. The entire Governance Committee stands in opposition to this provision. As you note from PSD's testimony, the Savin program receives no general funds at all, and it's funded through an offender fee of 4% tax on commissary purchases, but in large part through this telephone tax. The creation of this self-funded program, it was funded initially through a federal grant, and then when the grant funding ran out in 2012, the Women's Caucus of Legislators, this program is one of the Women's Caucus bills, to the creation of this self-funded program to protect victims and community safety. It also was a justice reinvestment initiative at the same time, although it was a Women's Caucus bill. And it was really in recognition of the fact that as we did justice reform, and we were going to move offenders more quickly through the facility, that we needed to make sure that victims in our community were protected. We needed to make sure that they were safe. And how we make sure that victims are safe is they're notified about impending release of offenders so they can do safety planning. They're notified about when there's an escape of an offender. They're notified about their right to speak at the parole hearing so that the parole board can know what the impact of the crime was on them and to make an appropriate decision about victim and community safety. So but prior to the implementation of this system, it's sort of detailed in our testimony that it was kind of a catch-can manual system before this automated system. Victims often didn't get notified. We'd hear sometimes about a victim would run into an offender in the community. They would not even know that they were going to be released before the development of this important system. Numerous citizens were unable to exercise their right to speak at parole hearings. They were traumatized when they were not notified in advance about offender movement. So this is a really, really important program to safeguard victims, survivors, and our community. Without this funding, without it being self-funded, the program would end. It's a blind system. Nobody knows who the people are that have signed up. It's a private system that victims can sign up for in the privacy of their own home to get this type of notification. Some of the domestic violence victims we know, they check this system every night to make sure where the offender is so that they can feel safe. That's how important and meaningful this system is to individual people in our community to be safe. So we urge you not to undermine this funding source. We note that while there have been problems nationally with sort of usurious rates being charged, the rate that's being charged in Hawaii has always been well below the Federal Communications suggestions, because it really was, when it was created as a system, it was a balance between the rights and needs of crime victims and the safety of our community and the needs of offenders. So this program really struck that balance, and that is why it was a part of the Justice Reinvestment Initiative, is because of that.
Okay,
thank you very much.
Okay, next up we have Hawaii Correctional, we have the commission in support.
We support this measure, and I want you also to know that we very much support the Savin system. It's just the method of funding for the Savin system that we disagree with. So often inmates and their families are poor and cannot afford to make these phone calls. And connection with families is very important to the reentry process and being connected to your community. We do want to bring to your attention that this, the issue of the cost of inmate phone calls rose to the level of the U.S. Federal Communications Commission, and they resolved it in part. They could only address interstate problems. But they said as part of their efforts to ensure the rates of interstate and international phone calls are just and reasonable for all Americans, the agency is working to rein in the excess rates and egregious fees on phone calls paid by some of society's most vulnerable people, families trying to stay in touch with loved ones serving time in jail and prison. We would also like to bring to your attention, you have an error in the bill, and that is we respectfully request that that a correction be made to Section 2, which amends 352, Hawaii Youth Correctional Facilities. The Office of Youth Services is responsible for HYCF, not the Department of Public Safety. So we ask that you delete the terms, the Department of Public Safety or its successor agency, and replace it with the Office of Youth Services. Thank you.
Thank you very much. Next up, we have Kauai Office of Prosecuting Attorney in opposition. No, not here. Next, we have Hawaii State Coalition Against Domestic Violence in opposition. And we have Women Prisons Project in support. And we have probably five more members in opposition or support. Is there anybody else wishing to testify on this measure? Go ahead.
Good morning, Chair, Vice Chair, members of the committee. My name is Leanne Gillespie. I'm the Executive Director for the Office of Youth Services. I hope maybe you don't have my written testimony, but I can provide that to you also. We oversee the Hawaii Youth Correctional Facility. It's the only correctional facility that holds committed youth. These are children, ultimately, and we do believe and provide free voice communication with family and.
Are you in support or opposition?
Sorry. I'm actually in opposition as it relates to the Office of Youth Services. I'm going to provide comments, and I'm going to defer to the Department of Public Safety. So
Okay.
we do already provide free communication for our youth that are committed. We don't believe that the Section 352 amendments are needed. If this bill is forwarded, we do ask, as the commish said, that the language for stating the Department of Public Safety under 352 be removed. Thank you very much.
All right, thank you. Next, is there anybody else wishing to testify? Seeing none, members, are there any questions? Representative Kennedy.
To Director Johnson. I was introduced to some issues with this bill when I reviewed the testimony. I didn't know that this was going to encumber the Save-In program or issues regarding the Office of Youth Services. Of course, the intent is to comply with federal law and recent federal decisions. How does the state contract with the private prison company, Core Civic, and how do inmates in Saguaro contact their family members or their attorneys?
Okay, so that's separate than this bill. We contract with Core Civic for X amount of beds in the mainland. There's also, as part of that contract, is the telephone services, and each inmate, regardless of correctional facility on the mainland or here, gets one free 5-minute telephone call every week. The rates are exactly the same as here, but I'll double check this to make sure. Is that correct, Sharon? Okay, I'm sorry. Core Civic has a separate contract than this contract here. So they have a separate contract with a vendor for inmate telephone calls.
And they charge the state, or they charge they charge as a separate contract, or they're just allowed to contract at whatever amount and they just pay it?
If I'm not mistaken, I'll have Shari Kimoto come up. She can explain the contract with Core Civic, because the telephone contract with Core Civic is separate from our contract with that facility, with that company. Yeah. Shari?
Aloha, my name is Shari Kimoto. I am the Division Administrator over Corrections Programs and Services with the Department of Public Safety. So in response to your question, the department does, through a competitive bid, contract with Core Civic for certain programs and services, but it is Core Civic's private contract with a telephone provider that does not impact anything within public safety. So we don't see any of their contract terms or anything. And I'm not even sure if CoreCivic uses the same vendor that we do, but they do provide a automated telephone system similar to us.
Yeah, there you go. Okay. Chair, if he's still in Star Wars line. And what can I do a follow up with Director Johnson? Yeah.
Yes.
Both as an attorney and as a member of this body, I've gotten collect calls from OCCC, and when I've missed them, individuals have not been able to leave a voicemail because nobody was there to answer the phone. How can we fix this if we don't move this bill forward? People who are inmates have really valid reasons to communicate with their family members or their attorneys, and they got to call collect.
If they make a collect call, someone has to be on the other end to accept those charges, if I'm not mistaken. So you're saying if no one is there and an answer machine picks up, or
you have to. I'm not sure if anybody else has done this. You have to press a few buttons,
right,
in order to accept the call, and if you don't accept it, then you can't, communicate with the person. And of course, they can't leave a message, and it might be rather urgent.
Mm-hmm. Well, one, it would be the responsibility of the receiving call, the receiving person who receives the call, to work with the phone company to automatically possibly accept those calls if they're not there to answer, and go to answer machine.
That seems like a lot of work, Mr. Johnson. I feel like I'm okay tech savvy, but I have no idea how to do that.
But the problem is, if an inmate's making any person incarcerated making a collect call, we would have no control over the other end of the call. I can check with our vendor to see, but that would mean that the person on the receiving end of the call would be somehow automatically accepting charges.
To follow up.
Yeah. Okay. Come on.
I'm sorry, I can answer your question because I run that system for public safety. So all inmates receiving or calling out, well, actually inmates cannot receive calls in prison or jail, but all of the numbers that they are able to call have to be approved on their phone list before they can call. So they can't just call any number in the community. It has to be approved first. So if you are receiving collect calls from an inmate, it's because your name is approved on somebody's, we call it a PAN form. And so there's two ways. They can either call collect or they can call you direct. So if you are an attorney and you're working on their case, there is an auto greeting that says to give us a number. There's a number to call so that we can actually go into an inmate PAN form. And if you are the attorney on file and you are not a private attorney, you're like with the public defender, or for some reason you are working on their case, we can easily just add you on as a direct call for a free call.
Why can't people leave messages?
They can leave messages. Well, they can't leave a message because the way the security of the system works is that the person receiving the call has to either press 1 to accept or not to accept. And that's just the security of the system.
Right. Do you see how that might hinder communication between family members, between attorneys, between people trying to assist people to get probation, move out of facilities?
So for probation and all of the court type court divisions and anything having to do with their case, they actually can make a direct free call using our speed dial system. And so there's usually a live person that answers the phone call. And for all purposes, like I said, all of the numbers that the inmate is allowed to call has already been pre-approved on their inmate PAN form. And so by allowing the recipient to either accept or not to accept the phone call, it could be because maybe they might be a victim that the facility didn't realize, and so we can not accept the call, or perhaps that person receiving the call is at school or at a shopping center or something where at that moment they can't receive the call, and so they just deny. And then the inmate is free to call back because they have unlimited phone calls.
Okay, thank you.
Thank you. Go ahead,
Just a
Representative
quick one.
Morikawa.
Because in the federal prison, I had experiences with email. I was able to receive emails from an inmate. Is the state not able to do that?
Not at the present time, not with the current vendor GTL that we have.
Is it something that's possible, though?
We can explore that possibility.
Can you please? Because I'm surprised. I did receive a lot of emails corresponding with the federal prison. And if that's possible, I don't see why we can't kind of look into it. Thank you.
Thank you.
Thank you very much. Any other questions? Seeing none?
We have 2 testifiers on Zoom.
We have 2 testifiers on Zoom? All right. Go on. Who is it?
Angelina Mercado with the Hawaii State Coalition Against Domestic Violence.
Okay, go ahead.
Aloha, Chair, Vice Chair, committee members. My name is Angelina Mercado. I'm the Executive Director of the Hawaii State Coalition Against Domestic Violence. We are a nonprofit organization, and we work on the systemic issues that affect survivors of domestic violence and their families. On behalf of our 28 member programs, we respectfully submit this testimony in opposition of HB 1133. This measure proposes to eliminate the SAVN system. And as Director Ferguson Bray previously testified, this is an important system vital to the safety of survivors of domestic violence. It would be untenable to think that a survivor would need to hear from somewhere else in the community, through the Coconut Wireless, that their abuser would be released from prison without advance notice. Without the SAVN system, survivors of domestic violence would not have the opportunity to work with an advocate, to engage in safety planning, to work with their families, to take care of their children in advance. Furthermore, it also gets in the way of their right to testify in any parole hearings if their abuser is up for parole. It is imperative that we maintain the independent funding for this program. We have a responsibility to survivors of domestic violence and to victims of crime in this state as well, to protect them. This is a vital system, and I think it would be irresponsible for us to eliminate it. Mahalo for the opportunity to testify on this important matter on behalf of victims of crime and domestic violence throughout our state.
Okay, thank you very much. Dennis Dunn. Okay, next we have Dennis Dunn on Zoom.
Good morning, Chair Hashem, Vice Chair Chun, members of the House Committee on Corrections, Military Affairs, and Veterans. My name is Dennis Dunn. I recently retired as the Director for the Victim Witness COCOA Services in the Honolulu Prosecuting Attorney's Office after 44 years of service. Before that, I was a volunteer advocate for People Against Rape. It is through that lens of my many years of assisting crime victims that I am testifying in strong opposition to House Bill 1133 relating to public safety. The provisions of House Bill 1133 would eliminate a critical funding source for SAVN, the state's automated victim notification system. The establishment of SAVN by the legislature in 2012 was a monumental accomplishment for crime victims in Hawaii, as it ensured automated notifications about the custody status of individuals in the custody of the Department of Public Safety on a 24/7 basis. The SAVN system ensures that critical information relating to victim safety is available to victims on a timely basis, allowing them to make important decisions and take timely actions to protect themselves from offenders. To ensure that the SAVN system was reliable and sustainable, the legislature established several funding streams derived from offenders, as illustrated by the excerpted language from HRS section 353-16 that I inserted into my testimony. And just briefly, it says that all proceeds and revenues that are derived from any commission, that is realized pursuant to a telephone service agreement executed by the department for the provision of telephone services for inmates shall be deposited into the automated victim notification special fund. In other words, the only beneficiary and recipient is the 7 fund. Without these dedicated funding streams, victims and their families would not be assured of receiving important custody updates that they have signed up for, thus creating additional anxiety and trauma. Please do not eliminate or weaken this important statutory provision. Crime victims and their families are counting on you. Please defer this measure. Thank you.
Okay, thank you very much. Anybody else wishing to testify? No more questions? I have one quick question for PUC. So Leo, if we just eliminate section 4, are you guys okay with that?
Oh, we don't take any position on the bill
Yeah.
entirely, but if it does move forward, probably some guidance on, after looking at that particular administrative rules that the PUC already has, if there's any tweaks that need to be done, but we think that it would cover it.
Okay. Oh, my question is, if I just take that out of the bill, then you guys are okay?
Oh, we think we're okay. I mean, whoever, if the bill moves forward,
Yeah.
and right, they need to provide this service, right? Eventually, the PUC, right,
We'll
has
have to tweak your, okay, I got it.
Yeah.
I'm gonna eliminate section 4.
Okay,
Put it that way.
thanks.
And then you guys can do what you need to do regarding this.
Yes.
Right? Okay,
Yes.
great. Thanks. Okay, thank you very much. Members, any other questions? Seeing none, we're moving on. Next up, we have HB 467. Relating to criminal justice reform. Hold on here. First up, we have Department of Public Safety in opposition. What?
Good morning, Chair, Vice Chair, members of the committee. The Department of Public Safety stands in opposition to this measure. We respectfully recommend that alternative initiatives be considered, such as allocating additional funding and resources to colleges within the state of Hawaii to increase their capacity for any interested individuals to obtain professional degrees in social work. Thank you.
Okay, thank you. Next up, we have Department of DCCA with comments.
Good morning, Chair, Vice Chair, members of the committee. My name is Rochelle Araki. I'm the Executive Officer for DCCA's Social Worker Licensing Program. The department stands on its written testimony offering comments. Please let me know if you have any questions. Thank
Okay,
you.
thank you very much. Next up, we have Hawaii Health Harm Reduction Center in support. Next, we have National Association of Social Workers Hawaii Chapter in support. Next, we have Will Karen, individual in support. Naea Lo in support, and we have Marilyn Mick in support. Is there anybody else wishing to testify? Seeing none? Oh, go ahead.
Aloha, Chair, Vice Chair, and the committee. My name is Angela Melody Young, testifying in strong support of the measure. So the purpose of this act is to seek a collaboration from the Department of Public Safety and the Department of Human Services to create a social work training program to help those who have been incarcerated to then help others. So this is very innovative and transformative as a solution in terms of criminal justice reform. And the measure is a positive step towards criminal justice reform, and it will help to address mass incarceration and recidivism as it provides hope and opportunity through a training program and professional pathways. A report from the Interagency Council on Intermediate Sanctions states that recidivism rate in Hawaii is about 48.9%, and therefore we have high rates of people who are likely to reoffend. So, Hawaii's high recidivism rates demonstrates the inefficiency of our current criminal justice system. And it doesn't provide inmates with resources that would allow them to be positive contributors to their communities once released. So investing in these initiatives has proven to be cost effective, and it would cost less to invest in these sorts of initiatives than to send someone to jail. It also reduces crime rates and recidivism. And this measure fights the stigma that those who have done something wrong deserve punishment instead of redemption. But isn't true justice achieved when incarcerated people are given the chance to restore others who have also offended the justice system? Oftentimes we think justice is punishment, but if you're the judge of all the crimes in the world and you have to be objective because you're the judge, and research evidence proves the root of the majority of crimes are behavioral and mental health conditions, wouldn't justice be creating equity and providing the resources to the criminals because they couldn't get resources because of socioeconomic disparities and cultural disparities? So 5 years ago, the US Senate passed the First Step Act, a bipartisan effort aimed at curbing recidivism. It provides aid to those behind bars by helping them transition back into civilian life. We can see an integrated effort and a strong cohesion of vision from the federal and state government, and so we are in strong support of this measure towards criminal justice reform. Thank you.
Okay, thank you very much. Is there anybody else wishing to testify? Seeing none, members, are there any questions? Seeing none, we're moving on. Next up, we have HB 1336. Now we're at relating to criminal justice reform. First up, Hawaii Paroling Authority in opposition.
Good morning. Acting Administrator Corey Rankin on behalf of Chairman Quinn. Stand by written testimony for any questions.
Okay, next up, we have Hawaii the Commission in opposition, or with comment, sorry.
We stand on our testimony. Thank you.
Okay, next up we have the judiciary in opposition. Oh, they're not here. Okay, next we have Office of the Public Defender in support.
Excuse me. Good morning, Chair Hashem, Vice Chair Chun, members of the committee. My name is Lee Hayakawa. I am the Chief Deputy for the Office of the Public Defender. The Office of the Public Defender stands in strong support of HB 1336. As of January 30th, 2023, which was this past Monday, there were 1,102 inmates at OCCC. The reason this number is significant is because it far exceeds the operational capacity, which is 954 at OCCC. OCCC is currently at 116% capacity. OCCC, however, is not the only facility in the state that is experiencing this problem. On the Big Island at HCCC, HCCC has a operational capacity of 226. HCCC currently houses 304 inmates. HCCC is currently at 134.5% capacity. On Maui at MCCC, the operational capacity is 301. MCCC currently houses 335 inmates. They are at a 112 capacity. The stark reality of this situation is that we cannot continue to do what we have been doing for decades. This problem is not a problem that will take care of itself or resolve itself. The stark reality is that we cannot keep cramming fellow human beings into jails and prisons in Hawaii. HB 1336 offers at least a partial solution to this grave issue facing the state. HB 1336 provides the real possibility of getting those numbers down to where they should be. HB 1336, especially the amendments to HRS 803-6, is a thoughtful, carefully crafted bill that attempts to strike the delicate balance between public safety and individual rights. If applied correctly and in good faith, we believe HB 1336 can make a real difference. The Office of the Public Defender wholeheartedly supports all portions of this bill. Thank you for the opportunity to testify, and I will be available for questions.
Okay, thank you very much. Next up, we have Public Safety with comments.
Thank you, Chair, Vice Chair. I'm Tommy Johnson, the Director of Public Safety. We'll stand on our comments, but I just wanted to highlight one point. We offer specific comments on Part 2, Section 2. We'd ask you to really take a look at that calls for an amendment to HRS 804-7.2. Thank you.
Okay, thank you very much. Next up, we have Hawaii County Office of the Prosecuting Attorney in opposition. Next, are they on Zoom?
Aloha Chair, Vice Chair Chun, committee members, Hawaii County Prosecuting Attorney Keldon Walgen. We stand in opposition of this bill. We want to restore the public's trust in our criminal justice system. As a result, we believe that the custody determinations should be made on a case-by-case basis to ensure that the public and victim safety concerns are properly considered. Although we agree that this bill is well-intended, the consequences of this bill's overbreadth are concerning. I'll submit on our further arguments regarding those concerns as noted in our written submission. What I want to note is that, on Hawaii Island, it's not unusual that a large majority of the criminally accused are released on either supervised release, on their own recognizance, or have bail reductions granted. Those currently in custody on pretrial status at our main facility at HCCC are oftentimes pending several felony matters, have previously been granted supervised release and bail reductions, and had their release status since revoked based on alleged commission of new offenses. Judges oftentimes cite the conditions and overcrowding concerns at HCCC, which is located in Hilo, as the justification for granting release requests. Simply jeopardizing public safety concerns simply on the account of overcrowding and correctional facility conditions is misplaced and misguided. Perhaps prioritizing facility construction and repair would be a better use of time and resources. Understandably, these types of repairs and constructions are time-consuming and costly. In the alternative, supporting funding, staffing, and programs for supervision and reintegration services, and prioritizing the utilization of alternative forms of supervision, such as electronic monitoring, which is on our island underutilized. That would lead to ease overcrowding concerns, assist incarcerated persons reintegrating back into society, and provide them with the tools to succeed, and thereby reducing recidivism. Hawaii Island is a big island, but we're a small community. Community members have made it very clear that they no longer feel safe in their homes and communities, and that isn't right. Let's work together to address that. We submitted our written input, and I'm available to answer any questions you may have. Mahalo.
Okay, thank you very much. Next up, we have Trisha Nakamatsu, Department of Prosecuting Attorney of Honolulu, in opposition.
Good morning, Chair, Vice Chair, members of the committee. Deputy Prosecutor Trisha Nakamatsu, appear on behalf of the Honolulu Prosecuting Attorney's Office. Just to echo some of the comments made by the Hawaii prosecutor, we also agree that doing things on a case-by-case basis, allowing the judge or the police, for that matter, from the very beginning of the process to have the discretion to use their experience and all of the knowledge and information that's available to them, that should be available to them, to make this decision on a case-by-case basis. So we are in strong opposition to the bill. Although we do agree with the goal of eliminating cashless bail system at some point, this bill simply does not present the solution. We want to make sure that there is actually a reliable system in place before going to a cashless bail system, and the approaches taken here seem to just be largely grouping together some propositions that were already declined by the legislature in 2019 under Act 179, wisely so, we believe. To start with, Section 4, I'm just gonna point out a few sections, although it is our testimony goes into much greater detail. So starting with Section 4 on page 4, that would present a blanket prohibition from arrests for the majority of cases, and we feel that that goes way too far. It doesn't allow the police officers to use their discretion. Already there's been a change in philosophy among all the police departments, among all the judges and the court system, to not arrest, to not put people in jail to the extent possible and to the extent safe for the public. And that philosophy is not going away anytime soon. It's headed in even further in that direction, which is a good thing. But that said, what this particular section would do is it would prohibit police officers from arresting people who are going to most likely be charged with burglary in the second degree, negligent homicide, also known as vehicular homicide, arson in the third or fourth degree. Also such things as, there's a fuller list in our testimony, but things like identity theft, promoting pornography. If somebody's issued a citation, the first thing they're going to do is go home and wipe their computers. That theoretically they could. And things like that, we feel it's very important to give the police discretion to arrest when needed for the sanctity of the case, as well as the protection of the public, various reasons. Moving on then to Section 7, which starts on page 9. We would strongly oppose the elimination of those types of information from the pretrial bail reform. I'm sorry, pretrial bail reports. The courts and the judges rely on all of this information to make the best decision they can about whether this person can be released into the community without any conditions or what conditions would be appropriate. And they want as complete a picture as possible, as it would make sense if any of us were in their position. They have the ability to put different weights on different types of information. They want to know as much as possible to make sure that the person is likely to appear for their follow-up hearings and that the public is going to remain safe, and any particular people who may be affected are going to remain safe. This all goes into their decision-making process. It does not mean that the person is going to stay in custody. It could, and most likely does, mean that maybe appropriate conditions could be placed. But this is important information for them to know. Then continuing on in the process, Section 9, which starts on page 14 of the bill, with regards to Section 7, another thing is that section, if you only count convictions, it doesn't take into account deferrals, which are technically not convictions, but are certainly important for the court to consider if there was a deferred acceptance of a guilty or no contest plea. I'm sorry, Section 9 starts on page 14. That section, I think there might have been some typographical errors perhaps. It was a little bit difficult to understand, but our understanding of that section would make it not impossible, but highly unlikely that next to anybody would be kept in custody if they're held to standards such as the standards that are currently used for keeping somebody in custody without bail. That is the section that we referred to that would require, first of all, that the charge be a serious offense, and then that they meet one of these, it appears, they would have to meet one of these requirements, that there's a serious risk the defendant will either willfully abscond, obstruct justice, meaning witness, essentially interfering with witnesses, or pose a significant danger to an identifiable person, or possibly to the community. And then on top of that, it appears that prosecutors would have to prove that the risk cannot be mitigated, cannot meaning essentially impossible to be mitigated by any conditions that the court might set for release. So as we indicated in our testimony, these are actually more stringent than the criteria that are currently used to consider whether somebody should be kept without any bail at all, like no opportunity for them to be let out prior to trial. Typically reserved for murders and some of the most atrocious crimes, or the most concerning, where the court really believes that this person should not be out under any circumstances until trial.
Can you sum it up? It's a pretty long bill.
Yes,
So
I'm not
you-
going to go through any more of the sections. You have our testimony. We are available for questions, and that, I think, pretty much walks you through what the process would be like. We feel that this is deeply concerning for public safety, and we'd ask that the police and courts be allowed to continue to do their work on a case-by-case basis.
Okay, thank you
Thank
very
you.
much. Next up, we have HACDL in support. Hawaii Association of Criminal Defense Lawyers. Okay, next we have on Zoom ACLU of Hawaii in support. They on?
Good morning, Chair Hashem, Vice Chair Chan, and committee members. My name is Wookie Kim. I'm the legal director at the ACLU of Hawaii, and our organization strongly supports HB 1336. This bill is important because it takes steps to reverse 3 very harmful norms in our criminal legal system. First, this bill reverses the knee-jerk reflex of having police officers detain and restrain people accused of crimes through custodial arrest. Our organization has seen the deep harm that can be caused by arrests, not just to those who are arrested, but also their families and communities. By requiring law enforcement officials to use citations in lieu of arrest, for certain crimes, this bill reduces those harms and ultimately makes our community safer. Second, this bill reverses the devastating practice within our pretrial system of forcing people in poverty who are accused of crimes to prove that they should not be locked in a jail cell before trial. That's not how our system should be. As the Supreme Court has stated, quote, "In our society, liberty is the norm and pretrial detention is the carefully limited exception." This bill would breathe life into that constitutional principle by presuming that people accused of crimes should be free pretrial and correctly placing the burden on the prosecution to prove that one's liberty must be taken away. In doing so, this bill would help unwind this inhumane system of wealth-based detention. Finally, this bill reverses the automatic impulse to punish and incarcerate our way out of substance use disorders. This bill correctly rewires that impulse to instead provide treatment and rehabilitation to this vulnerable group of people. So for these reasons, and for those stated in our written testimony, the ACLU of Hawaii supports this bill, and if the committee has questions, I'm happy to answer that. Thank you.
Okay, thank you very much. Next up, we have Hawaii Health and Harm Reduction Center in support on Zoom.
Aloha, Chair, Vice Chair, and members. Nico Sleverins with Hawaii Health and Harm Reduction Center, testifying in strong support of this bill. We echo the comments made by the Office of Public Defender, and particularly the third comment just made by Wookie from the ACLU of Hawaii. Hawaii has the longest average probation term in the nation at 59 months, according to a 2020 Pew Charitable Trust report. And it's that way by design, unfortunately. It's been that way for some time. So this bill importantly, provides that a positive drug test, which is used for treatment in therapeutic settings, not be the sole basis for an arrest or a revocation of probation or parole. And the other aspects of this bill will help reduce the unjust pretrial incarceration of those from under-resourced communities. Mahalo.
Okay, thank you very much. That is all the registered people we have to testify. We have written testimony and support, about 24 other individuals in support, and about 5 or 6 other people in opposition. Is there anybody else wishing to testify? Okay, come on.
Good afternoon, Chair and committee. My name is Eric Irwin. I'm testifying in opposition. I did submit written testimony, however, it was not within the 24 hours. I'm a constituent of Representative Ganadan. And, part of the reason why, I like going last because I think they covered a lot of things that I wanted to mention. And one of the, sorry, just a second. So this bill is almost like a rehashing of bills that failed in the past, which was referred to. And this is it's coming back as bail reform. I think people have spoken enough on that. I'm not going to touch on my opposition. And I'm not against bail reform in and of itself. I'm against bail reform for the sake of bail reform. I think you need a supporting apparatus to, the drug treatment, mental health, all of those other things to really help the people that are released. But I think I want to speak more on the more, pernicious aspect of this bill, and that's that Section 4 that removes the discretion of police officers, law enforcement officers on the ground to make a decision of whether an arrest is appropriate in a variety of cases, ranging from felonies to misdemeanors. Burglaries, you can be caught in the act of burglarizing a house. You get sent away with a citation. The resident of that house has to live with that knowledge that that person is still out there, has to repair the damage that may have been caused as that burglary occurred. These are all aspects that the constituents, the vast majority of your constituents, are law-abiding. They don't burglarize, they don't do these things. And they now have to live with that. And I think that's part of my opposition to this, is that it forgets about that element. It forgets about the victim. It forgets about the person who witnesses a crime, who sees the police come, address the person who victimized them, and then gets sent off with a citation, as long as they don't hurt them, right? As long as they don't hurt the victim. This isn't just, and this isn't safe. And removing that discretion also has other consequences that the prosecuting attorney referred to. You know, I don't have as much to talk about because they shared so much, but I do want to share one quick story. And it's about one of my friends. And she works in a dental office, has scrubs, works 2 jobs. The husband works 2 jobs, very hard worker. She comes home on her day off. She washes her clothes and hangs them up in her backyard to dry. That night, all of her scrubs are stolen, $900 worth. And if that person was caught on video, positively identified, found, they would get a citation and sent off on their way. In the meantime, we talk about the embarrassment and hardships that are imposed by arrest on the perpetrators. She has to bear the cost of losing $900 worth of uniforms, replacing those so that she can return to work. Maybe the embarrassment of having to go to one of her friends and say, hey, I don't have the money to replace this uniform right now. Can you please let me borrow yours? And I think that's what we're losing sight of here, are the victims. You know, we have all these things, and there are so many, and anyone that thinks that the judges are just putting a massive amounts of people in jail, I would challenge anyone to attend a bail hearing. What the prosecuting attorneys said, and I believe it was in the Big Island, a lot of them are let go. I mean, it's not, and I support the ideas behind this. I just think this is so poorly executed and forgets about the constituents that largely are law-abiding. And I just ask that the legislature remember that. You know, I don't have a lot of reach. I'll go to the neighborhood boards, try to get people, aware of this, but I just think this just really forgets about the vast majority of the people that you represent. And thank you for your time.
Thank you, Aaron. We have your testimony. So, is there anybody else wishing to testify? Seeing none, members, are there any questions? Seeing none, we will recess. This is our last bit, right? We will recess for decision making. Okay, good morning, everybody. We're reconvening our Committee on Corrections, Military, and Veterans. First up, we have HB 824 relating to medical release. We're going to take Robert Mercer's amendments and put that into the bill. We're going to take, the chair is also going to take out the hard timeline, like 20 days and within 10 days. We're going to take out those dates as public safety mentioned, and put in the committee report to look into how many FTEs that may be required. That's a purview of finance, not this committee. So that is about it. Any questions or concerns? Seeing none, Vice Chair for the vote.
Okay. Okay, members, voting on House Bill 824. Chair recommends to pass with amendments. Chair and Vice Chair vote aye. Representative Ganadin?
Aye.
Representative Ichiyama?
Aye.
Representative Morikawa?
Aye.
Representative Poi Poi?
Aye.
Representative Takayama?
Aye.
And Representative Souza?
Aye.
Chair, your recommendation is adopted.
Okay, thank you very much, members. Next up, we have HB 1235 relating to corrections. This is the camera bill. What we're going to do, what the chair's recommendation is just to make this basically strictly a funding bill for cameras for all facilities and body cameras, body cams and cameras, since nothing works. And I forgot to say, we're going to defect the date to June 30, 3000. HMSO, can I defect date the last one even though we pushed it out? Well, never mind. The next committee can do that. So we're going to defect the date to June 30, the year 3000. This is not to make it take into effect 1,000 years from now. It's just so that way this bill will come around once again. So we're going to zero out the funding amount. We're going to put in also funding a zero amount for body cams, and we're going to make it to all facilities. So basically it's just a funding bill. We're going to remove the requirement for body cams, and it'll just be a straight funding bill moving through the legislature. Any comments or concerns? Seeing none, members? Vice Chair for the vote.
Okay, members, voting on House Bill 1235. Chair recommends to pass with amendments. Knowing the presence of all members, are there any members who wish to vote no? Any members wish to vote with reservations? Seeing none, Chair, your measure is adopted.
Okay, next up we have HB 861. Based upon the testimony that we received and even with the Commission's lukewarm testimony, we're going to defer that measure. Next up, we have HB 1133. This is regarding, what is this? This is the chair's recommendation is to make the change from, what is that? From public safety to youth services in the bill that was highlighted. Put in the committee report for finance to look at the SAVIN program. I don't see the nexus between phone calls and the SAVIN program, and special funds are supposed to have some kind of nexus. So I think this program should be funded via general funds, and I want to put in the committee report for finance to look at that. And we're going to eliminate section 4. Okay, any questions or concerns?
Sure.
Yes.
The reasoning for introducing this bill, I think, was well explained by some of the folks that testified. I didn't know until the testimony that this would implicate the SAVIN program or potentially the notification systems to victims. But this is a process, and I'm very appreciative of the chair for the amendments going to the next committee.
Yeah, I have concerns that the nexus between this the telephone calls and the 7 program doesn't really exist. So an attorney, what is the next? Judiciary will be able to answer that question better than I can, because if somebody sues, the funding may go away. So that's why I want to push this to the next committee so that gets addressed. Any comments or concerns? See none. Vice Chair for the vote.
Okay, members, voting on House Bill 1133. Chair recommends to pass with amendments. Noting the presence of all members, are there any members who wish to vote with reservations? Any members wish to vote no? Seeing none, Chair, your recommendation is adopted.
Okay, thank you, members, for your support. Next up, we have HB 467 relating to social work. The chair's recommendation is to make a effect date of June 30, 3000, and to pass this with an HD1, and that's it. Any comments or concerns? Seeing none, Vice Chair for the vote.
Members, we're voting on House Bill 467. Chair recommends to pass with amendments. Noting the presence of all members, are there any members who wish to vote with reservations? Any members wishing to vote no? Seeing none, Chair, your recommendation is adopted.
Okay, thank you very much. Next up, we have HB 1336. I am going to defer to Representative Ganadin. He has been working with the stakeholders on this bill, and well, I'll let him. Yeah. So I'm going to defer to the introducer of the bill.
Thank you so much, Chair, and thank you to all who testified. The discussion of pretrial justice reform has come up before the state numerous times over the last decade. We've had several task force reports that have discussed the issue, and now we have new ideas about best practices and data to talk about this. I'd like to remind folks that changing pretrial justice is supposed to be in concert with beefing up, supporting, and funding alternative programming systems. So the kind of support model that we know we all need for individuals facing problems with mental health or narcotics. And I'm appreciative that Chair and the legislature allow me to continue to work on this bill. We had a nice meeting with the Office of the Attorney General, and we've got more meetings to come. There are going to be some amendments that I suggest, and I'll try to be quick. In Section 2805, we'd like to change the initial court appearance and grace period, which discusses individuals who often appear before the district court who miss a court date for very simple reasons. They go to the wrong courthouse or room, or they miss a date like many of us do, and then they are issued a bench warrant. This changes that language to say if a court bench warrant for a person to failure to appear, initial appearance, or for a non-substantive. We're going to add the words non-substantive court hearing. On page 3, we're going to change the discussion about initial court appearances on line 16 to may and say instead of a shall. There was a lot of testimony from the Office of the Prosecutor for here and Hawaii Island regarding page 4, regarding 8036, a mandatory citation in lieu of arrest. So we're going to be inserting the crimes that the Office of the Prosecutor from Honolulu, as well as Office of the Attorney General, have listed in their testimony. Let's see. We are going to be deleting on page, I'm going to get to it, on page 9, discussing bail reports. We're going to be deleting line 18 and 19. So the Office of the Prosecutor's concerns regarding prior arrests in a defendant's criminal history. And we still have some language to work on with regards to individuals who are automatically incarcerated for positive drug test and which leads to a violation of probation and having them sent in. This affects hundreds of people throughout our community, and oftentimes the court, even the prosecutor, wants to send them to a diversionary program, but those diversionary programs are full, or we don't have an adequate state program to kind of monitor these folks in an in-between way, instead of sending them directly to custody to an appropriate program. So myself and the Office of the Attorney General, we vow to work on this HD1 during the day and get it in for a draft to be sent to the next committee.
That's it?
That's it. Thank you.
Thank you very much, members. It is a work in progress. Oh, and we're going to defect the date to June 30, 3000 to make sure it goes into effect 1,000 years from now.
Chair.
Any questions or comments?
Just a comment, Chair. Thank you. Thank you for those amendments. However, I'm still very sympathetic to the victims, and I do agree that this does need more discussion, and maybe we will come out okay in the end, but for now it's reservations for me. Thank you.
Thank you.
Sure. Thank you very much. Anybody else with reservations?
Chair.
Oh, with reservations for me too, I would like to also express the same sentiment as Rep. Morikawa, but I do agree with the intent of criminal justice reform and what Rep. Gannon is trying to do. Thank you.
Thank you. Anybody else?
Sure, I have, thank you. I have strong reservations about the provision that exists in the bill, which is that police would require to issue a citation in lieu of arrests in case of not only misdemeanors, which exists, misdemeanors and petty misdemeanors, but also felonies. Because, in other words, there would be no discretion on the part of police, and they would not be allowed to arrest persons in many cases that are of concern to the public. Therefore, I have very strong reservations about keeping this language. So for those reasons, I will vote with reservations.
Anybody else has reservations?
Oh, no, the proposed HD1 would include C felonies as requested by the Office of the Prosecutor here in Honolulu. So
you mean remove?
Remove C felonies. So to address your concern,
okay.
It would remove C felonies.
But it would still be shall rather than may.
That's the current draft.
Okay. Yeah, but for those reasons, I still have reservations. Thank you.
Good. Anybody else? Okay, seeing none. Vice Chair for the vote.
All right, members, we're voting on House Bill 1336. Chair recommends to pass with amendments, noting the presence of all members and reservations from Representatives Morikawa, Takayama, and Souza. Are there any other members who wish to vote with reservations? Any members wishing to vote no? Seeing none. Chair, your recommendation is adopted.
Okay, thank you very much, members, for your support and allowing the bills to go forward. It's a work in progress. Mahalo. We are adjourned.